Hello, I'm Dave Steinfeld, a Florida Bar board-certified business litigation attorney. That means I'm recognized as an expert in business litigation law. The video you're about to watch is from a talk I gave entitled A Primer on Florida Business Litigation. This particular video examines liabilities within a company and from outside of a company. This video is not intended to provide legal advice to you, but merely to give you background information on this topic. After you've watched the video, please take a look at other videos and articles on my website, www.davidsteinfeld.com. Thanks for watching. Let me talk now about some of the internal liabilities that businesses can face, as well as liabilities to third parties. The easiest example to use most generally is a small, closely held LLC, limited liability company, because that's what most of the businesses are in the state of Florida. Internally, either be it an LLC or a corporation with shareholders, the managers of those businesses have certain legal obligations that are found in Florida statutes. Fiduciary duties, we call them, to the shareholders of a business, to the members of the company, to the other owners and directors or managers of their business. For example, if a manager of a business was to decide that he or she was going to simply withdraw money from the corporate bank account and take a vacation, if that's not something that's authorized, it's not within their job description, the shareholders of the corporation or the members of the limited liability company potentially have the right to say to that director, you're mismanaging the company. You're taking money for your own purposes. They are ultimately the ones who own the company, shareholders in particular in that situation. They have rights under Florida law that are directed at the managers of the company. So you all who are here, who are primarily CFOs and in the financial industry, you may find yourselves in the position of being a director or a manager of a small business. You should be aware that anyone in that position has certain obligations and duties to the other managers and to the shareholders or the members of the business. Another area that oftentimes is found as liability within a corporation are where the managers or the owners of the company or directors take or usurp a corporate opportunity. What I mean by that is if someone brings an opportunity to a company, to one of the officers of a company or a director or the manager of an LLC, and says, you can invest in this new project and make a lot of money. That offer is being presented to the individual in his or her capacity as the director of the business or the officer of the business or the manager of the LLC, not as the individual. If that person says this is a golden opportunity, but I'm not going to give it to the business, what I'm going to do is say, no thank you, the business is not interested at this time, but I'm going to go home and I'm going to pick up the phone and call that person back and say, hi, it's me. I'm taking off the hat of being the director of the company. Now it's just me as an individual. I want to invest in that opportunity. The opportunity being offered to the business is being taken by the insider of the business for his or her own uses, his or her own devices and benefit. As an officer or director of a business, as a manager of an LLC, those individuals have a certain obligation to the business. They can't do that. The shareholders, again, or the members of the business, have the right at that point to pursue legal claims against those managers to say you usurped a corporate opportunity. You had to offer it to the corporation first, and the corporation had to reject it. What are some of the responses then that we often see in business litigation to internal liability and internal strife within businesses? There's basically two. One is a dissolution, and the other one would be a shareholder appraisal in a corporation. A dissolution is more commonly referred to as a corporate divorce, because essentially that's what it boils down to, particularly in a situation where you have an LLC that is operated by two people who are, in all practicality, partners. If they can't get along, if they can't decide on the course of business for the entity, if they can't decide on whether to go left or to go right, how much to spend here, how to market there, and they're at odds completely with each other, and those decisions, that deadlock cannot be broken, then the individual who might be a minority shareholder, might not be a minority shareholder in the business, has the right to file a lawsuit to dissolve the business. Now, the LLC statutes are not as well developed in this area yet as the corporate statutes, so it's a lot easier for us to examine the corporate statutes at this point. But it highlights why it is important, particularly for LLCs, to have a very clearly drafted and well-worded operating agreement, because in the absence of that kind of documentation, the individuals who have the internal strife in the business may find that they can't get relief from a court if the statutes don't provide a support for it. So looking at the corporate statutes, we have a very robust and well-drafted scheme that's based on the Model Business Corporation Act and draws its base of knowledge from New York law, from Delaware law, which has very well-developed corporate law, as well as our own body of law in Florida. A corporate dissolution of a corporation under Chapter 607 of our Florida statutes is where one party would bring the lawsuit for dissolution, saying that the directors are deadlocked or the shareholders can't break the deadlock, or any number of qualifying factors that are found in the statutes, if not in their own shareholders agreement. At that point, there's an interesting switch that can happen. The other person who is involved in the business, or could be other people in the business, other shareholders, other directors or officers, can make an election to buy out the complaining shareholder and avoid the dissolution of the business entirely. When I said that it's an interesting switch, what happens is the lawsuit switches from a dissolution of the business to a valuation of the business. The dissolution lawsuit is essentially paused by the court in favor of having the complaining shareholders' shares valued, oftentimes by a business valuation expert. Usually both sides will obtain their own experts, and the issue that the judge has to deal with is which business valuation expert is correct, how to divide up the shares between those two. And there are other claims that can come into play, such as if the corporation has not been properly managed. It's not always necessarily a 50-50 split, but that's where business litigation attorneys can guide you and guide your business with their expertise. The end result of a corporate dissolution can be the purchase of the complaining shareholder shares. It can also be, if the election is not made to buy that individual out, it can also be the dissolution of the business, which would be the liquidation of all the business's assets and the judicial dissolution and termination of that business. If a business has a going concern, it's operating, it's earning money, people are employed in that business, generally it's more beneficial for everyone involved for them to buy out the complaining shareholder, and that's why I mentioned it's commonly termed a corporate divorce. Another response that we often see to internal strife and liability inside of a corporation would be shareholder appraisals and appraisal rights. Those are also found likewise in Florida's corporate code in Chapter 607. However, it's different than a dissolution in that the complaining shareholder may not have the rights to trigger a dissolution or may not want to dissolve the entity. There may be an event that occurs either by statute or in the shareholders agreement that triggers the appraisal rights to have the corporation buy out the complaining shareholders' shares. I'll give you an example of how this is actually seen in the real world in all practicality. I represented a client not too long ago who was in business with her boyfriend, significant other. So it was really like a partnership in that sense. It was a small, closely held business, just the two of them. And they were a very cash-rich business. The nature of their business required that they keep a lot of cash on hand. had several $100,000 in the bank account. And unfortunately, a problem developed between the two that was completely unrelated to the business. It was in their personal lives. And the response that my client's boyfriend took was to take all the money out of the corporate bank account, transfer that to a personal bank account, notify the state that my client had been removed from the corporation unilaterally, created a new bank account for this corporation, and moved the money into this new bank account. It was essentially what we would also term sometimes a minority shareholder freeze out, except they were 50-50 owners. She was literally locked out of the business and found herself no longer an owner of the business on paper, and found herself without access to the corporation's monies, half of which were hers as a half owner of the business. We were able to efficiently utilize the court system to bring a lawsuit for dissolution, but to within that obtain a very quick injunction by the court that prevented the other party from moving that money anywhere. The effect of that, the net effect, was to grind the business to a halt, and it instantly resolved the matter between the two of them and actually wound up being a very positive result for my client.